case briefs, and so much more. LSData's got what you're looking for.
An Iowa Supreme Court hearing in 1996 made a crucial ruling on the matter of lease contracts and tenants' rights. The case was Aurora Business Park Associates, LPV Michael Albert Inc., and its central focus revolved around the legality and applicability of an acceleration clause in a lease agreement. The dispute arose when Aurora Business Park Associates, LP, the landlord, filed a lawsuit against their tenant, Michael L. Albert, over unpaid rent. Michael Albert had breached the lease agreement, and as a response, Aurora invoked the acceleration clause to recover the remaining lease rent. The validity of the acceleration clause became the key point of contention between the two parties. Previously, a lower court had upheld the acceleration clause and awarded the landlord damages for the remaining lease term. It was upon this decision that Michael Albert appealed, triggering proceedings in the Supreme Court. In an unexpected verdict, the Supreme Court upheld the lower court's decision, validating the acceleration clause as a legitimate part of the lease agreement. The court, however, made it clear that while Aurora Business Park Associates, LP, was entitled to the remaining rent due under the acceleration clause, they were also obliged to credit any rent received from reletting the property. The Supreme Court thus prohibited the landlord from double-dipping, retaining both the accelerated rent and the rent received from a new tenant. The court further remanded the case to the district court to verify if rents had indeed been collected from a new tenant during the remainder of the lease term. This marked a definitive resolution to a complex legal dispute, setting a decisive precedence for landlord-tenant relations in Iowa.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.